Good afternoon, ladies and gentlemen. My name is Florence Shako. I'm the Vice Chairperson of Women in Alternative Dispute Resolution, and I'm really excited to welcome you today to this webinar. I can see we were being entertained by some podcasts before we joined, but such is life. If you can hear me on the chat, maybe say hello to one another. Maybe introduce yourself
Hello.
on the
Hello.
chat. Just on the chat, maybe you can type hello or good afternoon. Tell us something about yourself. Are you a mediator? Are you an arbitrator? Are you just an advocate? Are you maybe an architect? Some people are not lawyers. I can see lots of hellos coming through. So that is that is wonderful. Thank you so much for joining us today. And this is a Women in Alternative Dispute Resolution. We call it WADA, webinar. And the topic for today is between custom and justice, reimagining traditional dispute resolution through a women's rights lens. Now, we know that ADR, we have so many different mechanisms. So today we were excited to talk about traditional dispute resolution. But before we get there, I just want to say something about women in ADR. Women in ADR is a nonprofit. It's based here in Nairobi, Kenya, even though we operate across Africa. And what we do is that we try to platform women in the field of alternative dispute resolution to create a more inclusive field. So we have a very diverse membership, and I hope a lot of you can join us and become members as well if you're not. And we are really, really excited to have you here today. As I said, ADR encompasses so many mechanisms. We have arbitration, we have mediation, but today we wanted to focus a little bit on traditional dispute resolution mechanism, which is something that is gaining traction in our country. But we wanted to talk about it from a women's rights lens, and we hear from various speakers more about it. But for today, I'm not the one who's running us through the program. We are very fortunate to have Dr. Susan Kenyeki here with us, and I'll just introduce her briefly and then I hand over to her. Dr. Susan Kenyeki has over 24 years of distinguished professional experience in public service with very deep specialization in ethics, integrity, governance, and anti-corruption. Currently, she's serving at the Ethics and Anti-Corruption Commission, the EACC, where she's made significant contributions across multiple functional areas. She has expertise in mediation, in legal practice, in investigations, performance, contracting, you name it. And she's always shown an unwavering commitment to governance. Now, I could go on and on because her CV is just excellent. But what I can say is that we are extremely fortunate to have such a wonderful woman with a PhD in governance and leadership to guide us through this discussion, and also with a passion for ADR. She's an active member of Women in ADR. And thank you so much for creating the time today, Dr. Kenyeki. Please take us through the program for the day, maybe introduce for us the speakers, and let's kick this off. Again, thank you very much for those who are joining. If you joined a bit late, I said say hello to us, tell us, hi, I'm an advocate, hi, I'm a mediator. Let's keep the chat active and let's have a very interesting, engaging session today. So thank you so much for joining WADA this afternoon, and we hope to have a good conversation. Dr. Susan Kenyeki, over to you.
Okay, thank you very much, Madam Shako, for that warm introduction. So ladies and gentlemen, we are very, very excited to have you this afternoon. And without further ado, I'm going to introduce my panel. We have a very, very eminent panel with us in the house. Let me start with Madam Jeremiah Teresia Aluda. Madam Teresia Aluda is an advocate of the High Court. She's also a consultant on rule of law, accountability, and human rights. She holds a master's degree in law and a master's of arts in project management from the University of Nairobi, where she also did her LLB. And she's a PhD student in the same university. Madam Jeremiah Luda serves as a secretary to the Landesa board. This is an international organization championing women's rights and is a former member of FIDA. She is a consultant, and we are very excited to have her here. Her main takeaway, her motto is this, that if you can vision it, you can have it, you can become. Very, very positive. I now move along swiftly to introduce our second panelist. This is Mr. Kilonzo Kagangi, and we are very excited to have Mr. Kagangi with us because we are talking about issues to do with between customs and justice, reimagining traditional dispute resolution through a woman right lens. So even if we are women herein, we also have men who are our supporters, and Mr. Kagangi is one of those. He holds a Bachelor of Arts from the University of Nairobi, having graduated in 1980. I noted when I was going through his CV that he went to Alliance High School. I have noted that very well. He's a teacher by profession, and he has taught many schools from 1980 to 2008. He also trained A-level examiner in literature paper 2. He also has other very commendable experiences, that is presidential awards scheme. This is Machakos and Kitui. He was the chair. But suffice it to say that he trains women in community affected by mining on land rights for Haki Madini and Caritas in Kitui. He enjoys a number of things, traveling, reading, etc. But allow me to now take this special opportunity to introduce our guest all the way from Nigeria, Lagos in particular. This is Madam Adedola Adetokunbo Ajayi. Allow me, because where I come from, I may not have pronounced it correctly, but allow me to introduce this wonderful lady all the way from Lagos. She's a legal practitioner in Lagos with expertise in dispute resolution and arbitration adjacent work. She's an associate member of the Institute of Chartered Mediators and Conciliators with technical grounding in alternative dispute resolution and a commitment to fostering inclusive dispute spaces. So members, colleagues, we are very, very excited to have our three panelists. And without further ado, I must say that I'd like to invite Madam Jemima to specifically tell us on what are her reflections on the topic of the day. Madam Aluda, take it away. You have 7 minutes.
Okay, yeah. Good afternoon, fellow practitioners or champions on alternative dispute resolution mechanisms, including alternative justice systems, and welcome. Today we have a very interesting webinar that talks about custom and justice. How do you imagine traditional dispute resolution through a woman's rights lens? Yeah, we need to look at things from the woman's lens. I don't know, one of the notions that comes into our minds is that it's all about patriarchy, it's all about inhibiting the work of women in terms of getting justice, looking at positionality of the women, either in their roles as dispute resolution mechanism people, or in terms of them appearing before these traditional customary forms. So I'll be able to look it from three perspectives. Number one, our history or the past, and then number two, the present, and number three, what we are advancing or advocating for. So in terms of the past, we all know that not only in Africa, but globally, we've started with women being looked at as a second species or a second second to men. And when we go for meetings and sessions, we find the roles of women as more subordinates, in the sense is like supporting. One of them being women looked at as the ones who are just to pray or to serve teas or just to clean the place to ensure that we've created a pathway, like taking the role of being John the Baptist. That was the past. And this past is not just in Africa, but it's been something global. In fact, the movements of feminist movements began in the US, where we are trying to advance for the rights of the woman of color, and moving from the woman of color to women. So Genesis started with the radical feminist, the liberal feminist, the Marxist feminist, and now we came into the issue of intersectionality. So in terms of customs, justice, and traditional dispute resolution mechanisms, we need to look at it from the intersectional perspective, looking at women not as just one terminology or one brand or one category woman, but how do we look at women from their different spaces, from their different places? The rural woman versus the urban woman, the working woman versus the woman who is not working, and the woman who is at the core in northeastern in that kind of setup versus the woman who is now in the cities, looking at them from different angles and not just having one terminology woman, then asking ourselves what are some of the opportunities that these women either get or fail to get by virtue of their position in the society.
A reminder that it's the moments that matter.
So look at it from that intersectional view. That is number one, categorizing them in different perspectives and asking ourselves, how do they access justice? How do they view justice? To the woman in Northeastern, they have no other platforms because, first of all, the distance to court. That's number one. The environment itself. What are the mechanisms available to them that are within the society? It's totally different from the woman who is in Kibera. The woman in Kibera who is seeking justice will be asking himself or asking herself, how do I even go to court to spend 3 hours and leave my business here, which I know by the end of the day I'll have gotten something for my children. If I close my shop, go to court, stay in court the whole day, come back, I'll have lost my customers, but I also have lost a revenue to be able to feed my children. So you can see these women have different perspective or perceptions of justice, and they have different understanding on what they need to do to get justice. Having said that, we go into the Constitution. What does the Constitution provide? It provides that we need to give opportunities for all. That is the national values. Opportunities for women to access justice within their spaces, opportunities for women to be represented as people who can actually give justice, their roles, sitting in as the heads of those panels, sitting in as the chairs of the panels, sitting in as secretaries of the panels, but also opportunity for us to use a language that women can be able to understand. This goes into married women who are married in areas where the language that is used is not familiar to them. So even as we talk about right to culture, even as we talk about national values and principles of governance, how does this woman get justice even in their space, in areas whereby either they cannot understand the language, number two, they're not even welcome in that community, and number three, the opportunities hinder them to be able to effectively get justice. So the current situation that we have is that these women really want to have justice within their spaces, whether it's a rural woman or an urban woman, whether it's a working woman or somebody who is just within the space where they cannot have finances to finance their matters going to court, because you know that it's very, very costly. Whether it's a woman who has been married in a community, she cannot understand the language and the practices, but wants to get justice in that particular community. The current state is that, or the current statistics show that 80% of people want to get justice outside court. But more importantly, women themselves find justice accessible to them, these other alternatives that you have, rather than the court. And I'll explain why. Number one, I've given the example of Kibera, where somebody thinks if I go to court and close my shop, I'll have lost my revenue, I'll have lost my customers. And getting a customer in such an environment is very, very valuable to them, that when you lose one customer, it's like you've lost your livelihood. Cost implications. It's very costly for women. We all know as practicing lawyers that even filing matters in court, succession and payment of legal fees and all that, even court fees themselves, even running down matters, it's very, very costly for them. So cost implications. Number three, time. When a woman goes to court, often they have left their children either with a nanny, they've left their children the whole day, they close their shops. So they find that at some point they have burnout of going to court. Then number 4 is they still feel like going to court, you're already in a position of vulnerability. And so the person who has the money to the woman feels like this person will get more justice than you. So when they look at these forums for getting justice, to them, they feel like it's already undermined their agency, because they feel like they cannot fight with the high and mighty. In this regard, these other forms are available to them. But what do we do to ensure that the forms are within the constitutional principles and constitutional values? We need to embrace that the outcomes of these forms are not repugnant to justice and morality, number 1. Then number 2, we need to ensure that there is inclusion of women sitting in these panels, either as an arbitrator, a mediator, or an elder. We need to be able to do that. We need to decolonize even the language that we use, because most people think an elder is somebody who is a man and must have gray hair. Not even look at the dictionary that says elders must be somebody who's respected in the community and in the society. So we need to decolonize even some of these terminologies that we use, so that it can give them the opportunity to belong and to feel that they are part of this society. Last but not least is embracing the human rights framework, so that everything that is done, even in these traditional spaces, must be done within the human rights parameters. Thank you, and back to you, moderator.
Thank you very much, Madam Jeremiah, for those reflections. Now, can I hear Mr. Kagangi? Mr. Kagangi, take it away. And in the meantime, members, please feel free to put your questions in the chat so that we can address the same. Mr. Kagangi.
Okay. Thank you very much, moderator. I hope I can be heard. Am I audible?
Yes, you are. Proceed.
Okay. Okay. Now, maybe I would like also to look at this ADR issue from the historical perspective. Before the coming of the colonialists, we had societies. African societies used to exist. And of course, wherever there's a society, there's a community, there are people, there are, issues which need to be addressed. So there was a system which was being used to address the issues of either conflicts. And that's the one now we are calling alternative dispute resolution or alternative justice system, AJS, whichever terminology one chooses to use. And from an historical background, especially I'm looking at the canvas, before the coming of the Europeans and then the advent of the new, the common law as you practice it in courts, we had a system where disputes would be resolved within the community. And that time it was not alternative because there was no other method of doing it. And, there was a hierarchy of who was supposed to do what, when. For example, if there are matters involving land, those ones would be dealt with by the elders. And when I talk about the elders, I mean the clans. Now, there were other domestic issues. Now, when it comes to domestic issues, they were supposed to be.
Is this one?
They were supposed to be arbitrated upon by prominent ladies of the community. They would form their own, judicial system to handle this. Now, when the Europeans came, now they came with their own justice system, and then the tribal chiefs, the tribal elders, and everybody else was pushed aside. And then now this brought some a lot of dislocation in the society as far as justice is concerned. For example, in the Kamba community, one issue of land has become so prominent now about whether women should own land or should not own land and the likes. But in the traditional society, it's unfortunate. Land belonged to women, not the men. Why am I saying this? Because any man who was not married was not entitled to land. You are only entitled to land when you are married because you have children and the children need to be fed and they are supposed to be fed from the land. And that is actually women used to give land to their daughters-in-law, and no man would inherit land if you are not married. But now, bring in the British and the colonial systems of thinking. Now, land became a paper, title deed, and who is going to be registered? Anybody with an ID. Now, unfortunately, until 1979, women did not have IDs in Kenya. So who got the land registered into the man? Because he's the only person with an identity card. Now, with that came another story of now you can alienate land through selling. Now, in the traditional community, you could not sell land. You could only give land maybe to a clansman who had no land, or a sojourner who happens to come into your clan and pays whatever is supposed to be paid, and then he becomes a member of that clan, he will be given piece of the land. So land issues now is one of the problems where we are finding women actually pushed to the edge because the land belongs to the man because he has a title deed. The man decides to sell the land, he sells the land, and who ends up suffering? The children and the wife. Of course, you know, when children suffer, the mother suffers more than the father. So that is one problem, I think, where we are finding the courts a bit deficient, and we would encourage if we would go for alternative justice system, alternative dispute resolution, particularly when it comes to matters of land. Because sometimes we know that the elders know who occupied which land, when, and how. But now, when you happen to go to court, like somebody has just said, somebody with the money might get a very good lawyer, and the good lawyer could argue things which this woman cannot understand, and she'll end up losing the land. And actually, that is why sometimes we feel that some matters need to be resolved at the community level before anything else, because the community understands the intricacies of the people, and they understand some of these issues better than the common law as we practice it. Okay, it is common, but I think it is not very common to us. Now, in the traditional society, customs, justice was divine. There was no difference between justice and any matters religion, because if it came to a point where people, a group of people or a person felt that they are being denied their rights, justice is not being delivered, then we would resort to divine consultations. And this one applied especially if somebody was felt that is more strong than the other one and is taking advantage of the weaker person. Now, this is now where, the rights of everybody would be guaranteed, because everybody would be afraid of divine interventions. So now, next is when we look at the courts. I'm not really against courts per se, but sometimes when matters are adjudicated in courts, we end up with enmity within the society. There's more enmity created than peace. And we look at justice as a way of ensuring that there is peace for within the community, okay, we disagree on one matter. Maybe we are fighting over a piece of land, but the way the matter is adjudicated, each one of us is happy with it. So now with the court, sometimes we end up with a lot of enmity. So it's not as good to us as the communal way of dealing with disputes, particularly civil disputes. Even some criminal issues used to be dealt with because, of course, we had the highest court in the Ukambani, which we used to call Kengole, which would give, that was like the Supreme Court, and they would pass, capital punishments and the likes. Now, there is the issue which has been raised about time and language. Of course, the time people take to have matters settled in court is inordinately very long. Sometimes you go and then, for technical reasons, of course, the new constitution was saying that we should not make matters too laborious because of technicalities, but still the technicalities will still come up. You find that issues, you go to court and it has been adjourned. You come again, it has been adjourned. You come again, sometimes it is costly to the poor person. And mostly the poor people
we want to know.
Yeah.
Sorry, could you kindly mute? Mr. Kagangi, just wrap up the point. Whoever has their mic on, kindly put stop. Mr. Kagangi, kindly.
Okay.
Summarize.
I'm okay. So I don't know whether somebody was raising a question. Or
not quite. You can just summarize. Questions will be raised in a structured manner. Just finish your thought process, kindly.
So what I would maybe summarize by saying is that things have changed a bit, because during the old society, the roles of the women and the roles of the men were distinct. But now with the advent of the new economic system, now those roles have been merged together, because the man was supposed to provide for the whole family every time. But now these roles are shared. So as we share roles, I think new dispensation of looking at justice has to be, crafted, so that now we cannot rely on that customs, because the man would go provide security, provide food, provide everything. But now you find that the woman is also providing some of the income in the family. So how do you share the roles? How do you, bring in the gap? Maybe I can wrap it at that point. Thank you.
Thank you very much for that intervention. Now I would want to give this opportunity to one of our panelists, Adedola, all the way from Lagos, to give her reflections on this topic and her main takeaway. Madam, take it away. Proceed.
Hello, good afternoon. Can you hear me?
Yes, you can be heard.
Okay, thank you so much. I would be sharing short slides so we can discuss this matter more thoroughly. Give me a second. Okay. Can you see my slides?
Yes, we can see them.
Okay, thank you so much. So firstly, what I'm trying to, yes, okay, perfect. So yes, we'll be talking about reimagining the traditional dispute resolutions through women's rights perspectives. So usually when we think of the traditional systems, we know village councils, tribal courts, and then the modern ones are usually the formal courts and ADR. And the issue is that women are more likely to go to the traditional courts because it is easily accessible, they're more familiar with it, it's more legitimate to them. However, I would say that this is a double-edged sword in the sense that it is accessible, lower cost. However, there's patriarchal power. So women are usually excluded from these decision-making roles. There's a pressure to prioritize community harmony over individual rights. So women are more likely to have the expectations to forgive, endure, keep the family together, and then harm is usually reframed as a private issue, and then injustice is also seen as a cultural expectation. So we move on. So now we're going to look at the structural problems with this. So the issue is who is essentially sitting at the councils. As the other speakers had rightly said, it is mostly men, and they are framed as the elders, even though elders can be women, as the first speaker said, but they're mostly seen as men. Who normally frames this dispute is mostly the men as well, and who is expected to compromise is almost always the women. And the UN and the World Bank research has shown that in sub-Saharan Africa, the women are more likely to receive remedies through customary mechanisms than through formal courts, which is more likely because they are more used to these traditional systems. So privatization of gender-based violence, yes, it's seen as a private matter rather than a real matter that belongs in the courts. So look at this case study. A woman that seeks help from a traditional council after experiencing severe domestic abuse. Her council members are mostly the family members, the husband's uncle that she is even seeking remedy from. The focus is only on reconciliation, how to keep the family intact. That there's no protection order like in the courts, there's no safety plan, no accountability. So the woman is just essentially pressured to accept the decision just to avoid being ostracized. So now here we're going to talk about the legal pluralism. So Nigerian courts have not been silent on matters like this. So where customary law and statutory law clash, like Ukeje versus Ukeje, the Supreme Court had held that any custom that disentitles a female child from inheriting their father's estate is unconstitutional, and it violates Section 42 of the 99 Constitution on freedom from discrimination. So essentially, the courts are more likely to affirm the woman's statutory rights, and these cases they establish a legal baseline. So customary practices are only valid if they are consistent with the constitutional rights. However, in practice, a lot of the traditional dispute resolutions continue to apply the rules that they like, the rules that courts have already rejected. So as we see, the customary law may allow male-only inheritance. They may allow male-initiated divorce. However, statutory law allows equality and a right to divorce, a right to own property. And there are a couple more cases that in Nigeria that the Supreme Court has essentially held that women are allowed to hold property and they reject the customary law. So I think we should also see it through an intersectional lens, which is also how it affects different races, women with disabilities, and then women in different economic classes. So a woman with a disability, most of the time she would not even be in the discussion because they would give justifications and reasons why her testimony should be discredited because she has a disability. Also, economic, if you are poorer, you have less bargaining chips, and also race. If majority of the community is men, then you're less likely to even have a vote. So here we are looking at the women are usually told to choose between culture and rights. And I don't think it is a conversation that women have to reform their cultures or abstain from their cultures just because they want to be able to access this right. I believe both of it can intersect. The question is not the culture or rights, but whose version of culture and who gets to define it. Culture came from somewhere. Someone defined it. I believe that it can also be defined by women if they can get to have their say in these areas. So we're going to look at the feminist principles for reform. And essentially, the first is meaningful participation. A lot of the times people say women should be participating in these decisions, but decisions, but no one really gives a solid plan or solid example of how they can participate in these decisions. So I think we could reimagine it by essentially saying that outcomes of these councils that exclude women in making these decisions should attract reduced impacts. So if it essentially gets to court, the court should have a less look at it with less impact because a woman was not involved in this. Or if a woman, at least not one woman, is on the board, then the court should assume that this council lacks jurisdiction to even adjudicate on this matter. Then also we look at voluntary and informed consent. So a lot of traditional settlements, they rely on consent as a justification. Oh, well, she consented to be in this the hearing. She consented to be part of this when we made the decision, she was here. However, we don't, I believe that maybe the jurisprudence should not treat consent as neutral. So consent is invalid when it is obtained under compulsion, it is given under duress, and there's no genuine right to refuse. So a reform would be rights would be treated as settlements involving women's rights would be treated as voidable if you cannot show that consent is voluntary. So the first step would be showing that you got consent voluntarily, then we can then look at your decision. Then the last one is constitutional alignment. So as I said before, courts have already had their say that any custom that is inconsistent with the statutory rights cannot stay. So I believe traditional mechanisms should then be able to or should operate within the boundaries that have already been set by these Nigerian courts. Then so you can look at like global examples. So we can see that South Africa, they also trying to balance the customary law and constitutional rights. In New Zealand, they have a restorative justice that includes women elders. So these things can be done. As you can see, they're done in other countries, so it can be done in more other countries as well. Even in Canada, some indigenous communities have developed women-led justice circles. And then in Kenya as well, and Nigeria. Then my conclusion here is that culture is not static, it's always evolving. And traditional dispute resolution is not inherently good or bad. Their impact depends entirely on whether they reproduce or challenge the patriarchal power. So women would need to be more involved. We would need to train women. We'll have grassroots training. People need to go out, train this woman on how to handle legal discussions, how to handle dispute resolution discussions. And this will give them the capacity to be able to speak out in these traditional settings with the knowledge that they have gained. So I think this would be able to challenge the patriarchal power in this situation. So women will define what justice means, and it will be rights over efficiency and tradition, and they will be encouraged to transform. Thank you so much.
Thank you very much, Madam Adedola, for your submission. Now, please continue putting your questions in the chat box. But I'd like to ask Madam Jemima, you talked about cost being an impediment to justice. You can give us reflections. What can we do so that we can mitigate this cost? Madam Jemima, over to you. Madam Jemima? Maybe I can see she's still on the call. Maybe she's muted. Are you talking, Madam Jemima? Maybe you can unmute yourself.
Yeah, sorry. Yeah, I'm here. I was just trying to get into the Zoom, and I just love the reflections from the last moderator about what we need to do in terms of enhancing participation of women. And yeah, so my reflection about the costs. Sorry?
Yes, that's true. You gave us an example of Kibra and access to justice. So what is it that we can do within the spaces?
Okay, so within these spaces, so we all the whole world is moving towards people-centered justice, and people-centered justice now embracing alternatives to court and making it easier for people to be able to for justice to be accessible, convenient, and less costly. And so, in this regard, we need to build and empower more women to be able to be able to resolve disputes as either the panelists themselves or participate in the panels to resolve disputes. In this regard, when a dispute arises like within Kibera market, it's very easy for it to be resolved within just an hour, 2 hours, working with the chiefs, working with the elders, working with the community leaders. It's easier to resolve it rather than going to a long space of the formal court system, which will take a long period for them. And not only that, perhaps they may not get the justice that they require. Maybe somebody just wants restitution, but you go to court, somebody is incarcerated, and once the person is incarcerated, you yourself, you do not get back what you really want. So I think that's one way that we need to look at that. Number two, we need to go back to the cost in filing matters in court. It is very, very costly. You can imagine you're looking for any dispute that's about, is it 1.5 or so, you're told to pay 70,000. How many people can afford that 70,000? Even if it's a running down matter, and you've lost your husband in this case, you've lost your son. This was a breadwinner. You're trying to pursue the cause of justice, and you're told pay 70,000 shillings. It's very costly for these people to be able to afford. And this must be reviewed so that at least it can be affordable for these women who are seeking justice. And last but not least is, of course, to be able to employ, to implement the Legal Aid Act, so that at least the people who cannot afford legal services, then they can be able to get legal aid. And this is one of the UN basic rules that requires that you're able to provide legal aid to the people. But more importantly, as I've said, let's go back to the drawing board and empower as many people to be able to resolve disputes outside court as possible. Thank you.
Thank you very much, Madam Jemima. Now I come to you, Mr. Kinonzo. You did say that in the Kamba culture, actually land belonged to women, which I found quite interesting. What is the situation now? Is it still the same? And if a woman was not bearing children, would the situation change, Mr. Kilonzo?
No, the situation is not the same because of the changes on the perimeters of land ownership and the tenure. Because, that time the land belonged to the community. It was not individual. So the community actually, because they needed the woman for, production, the land was given to the woman to feed that tribe. I mean, the clan, maybe you would call it that way. And if you are not married, you're not given land. So for you to get land, then you have to be married. Now, if a woman ended up without male children who can marry, for her to give her land to their daughters-in-law, then they would marry what we used to call kawetu. Again, they could also be given a son by, if the man was polygamous, he could give that woman one of the sons to be a son. And that one now will give the continuity of that particular woman's household. The Kambas looked at property on household level. It belonged to the household, and the household was the woman. So like if a woman had so many daughters and they're married, all the cows, goats, and everything coming from that marriage belong to that woman. And they cannot be taken by the third or fourth woman. That is the way they used to deal with the communal property. Now, things have changed because now land is owned by title deed. And I had said earlier, title deed was based on an ID. Women did not have ID. So when most of the title deeds were issued, women never got the land. Secondly, now you can sell land to willing buyer, willing seller. Now, the woman will be left without land. If we could go back to where we were, some of these problems we're having would be solved. Because for one, you could not beat your wife. Because your wife is not your wife, belongs to the clan. Why beat her? If you don't want her, then we will go and build for her on the clan's land. And you have no business going there. She is our woman, our wife. So there was that protection against aggression. Very few men would beat them, because again, you beat your wife and then you'll have to give a goat or a cow, depending on how much pain you, of course, and then she'll be taken away from you and be, in the custody of the community. But now things have changed. We can't go back. What I would need maybe can be infused in the legal system now we are practicing, is that we give more prominence to the ADR, and it becomes more acceptable decisions. Like somebody has said, there's restitution in ADR more than punishment in the judicial system. Because in the judicial system, most of it is punitive, very little restitution. Because somebody will do something wrong to you, then he is jailed for 5, 6 to 1 year. What is your benefit? Nothing. Yes.
Okay, thank you very much for that reflection. Now I go to Madam Adedola, and I want you to address yourself to two things. Mr. Kiloso has given a perspective of how land was owned in that community. Now in Lagos, is it different, and what can we do? Thank you. Take it away.
Thank you so much for the question. So I would say in different communities have their own rules. Like now the Yoruba community, women are allowed to own land or own the property that after their father is deceased, as long as the property mostly goes to the elder, so the oldest person. And if it is a woman, then it is fine. However, there's some Eastern customs that women are not allowed to own property. But it is not it's mostly in the villages or some of the, if you are going to rely and consent to you being adjudicated on your custom. However, if you choose to follow the regular formal court rules, then a woman will be allowed to own property. But the courts have also said that those customs, the Eastern customs and other customs that don't allow women to own property, cannot stand. So if you take your matters to court, the court will allow you to own that property. So those are that's where we stand in Nigeria, Lagos.
A follow-up question. There is an interesting statement. You said that women are likely to get more justice in a customary than formal channels. So are you advocating that we stick to custom as opposed to formal channels? What is your take?
No, maybe you got me wrong. I'm not saying that women access more with traditional dispute mechanisms. I'm saying we shouldn't abolish traditional dispute resolution mechanisms. We can just reimagine them, change them up a bit. I believe if women are simply educated, because sometimes they cannot even see that they have a say. They cannot believe or imagine that they will ever have a say. So even opening up their eyes that you can have a decision, you can make a decision would be a first step to a turning point. Yes.
Thank you. Very interesting. Now, I would like Jemima maybe to give us reflection. Somehow we have given a lot of prominence to land, and therefore it would mean that land is a very emotive issue in Kenya. Jemima, Madam Jemima, from where you sit, what is it about land and justice that really gets our emotion very high? Madam Jemima?
Okay, so I think one of the reasons why land injustice becomes very much is because, first of all, even in the written laws, some of the written laws still are patriarchal in nature, and they deny women access to land. That is number one. For instance, in succession, we all know that women do not inherit anything. You are supposed to hold it as long as you remain femme solo. And you're holding it also on behalf of your children. And that's one thing that has never been dealt with all this time. Look at the issues of matrimonial properties and matrimonial rights. It's been a discussion on even marriage, on customary marriages, where most women fall in that category. So for them even to get access to that land, most of the land titles are even written in the titles are in their husbands' names. So for them, they end up not getting. But even going back to the community land, how many women have access to community land? It's community land as long as you are married in that community and you're not part of that community. So when women go back to where they came from, they're told you've been married. When they're going where they're married, they're told this is community land and you are not part of this community. So the women still remain hanging. And so what most of us have done is now try to look for these small plots that you can get in the CBDs for those who have the money. But remember, that is only but 10% of the women. So we still have challenges of them in terms of the laws that we have, the land laws, application of customary law, of which we know that 80% of the land is community and customary, and women still disqualified in courts from members of that community. So when the land is being shared, it's shared with your husband's siblings, your children, but you are still left out, and you cannot go back home to be to ask for any portion because you are told you've been married. And last but not least, now the issue of matrimonial, we still have challenges. Until now, we have debates about a recognition of customary laws in Kenya, whether it's been registered or not, and now that has an implication on even the properties that you have, and of course the properties in relation to land. Thank you.
Thank you very much. Now I'll go to our questions from our attendees, and we have 105 attendees as we speak. And I'd like Mr. Kilonzo to address yourself to the following question. Women need at least a third representation in the Council of Elders across the country. And my question to you is this: what specific interventions can you, as a women ally, do to ensure that we have a third representation in the council? Mr. Kilonzo. Mr. Kilonzo, you are muted.
If you're talking, you're muted.
Yeah. A third representation. Am I audible now?
Yes, you are.
Okay, thank you. Now, I had said earlier that things have changed a bit. The society has already changed, and we cannot go back to the old system of doing things. So we have to accept that women and men belong to this world. That's a fact. Things have changed. It is now provision of security is not done by the man, but done by the police. So the woman can get security without the man. Provision of economic gain is not by hunting. If you want meat, you don't go hunting. You go to the butchery and you need money, and the woman can have money. So society has changed. So we have to change and reinvent the way we do things. Okay, we will need not even a third. We will need to have a 50-50. Because if you leave half of your team at home and you go playing, are you likely to win? Because we have some women who are very gifted and knowledgeable, maybe in matters of education, maybe in matters of other issues. And maybe we are discussing matters education in a specific community. Do we need all men to come and discuss? Or do we need women who have got the capacity to handle the issues? So I would think we go for merit, not necessarily sex. Who can merit? If we have 20 women who merit to do something and there are only 10 men who can do it, let it be, so that we can move forward. That is my point on that.
Very
but
well,
just
very
one
well.
issue, one issue on that issue of land issue.
Yes.
In the Kamba community, every man who had a daughter could not give inheritance of all his land to his children. He had to keep one piece for daughters who are married in case they come back. There was a fallback. And
Very interesting. You keep a land to your married daughter in case they come back. In case
yes.
they come back. Okay. Very, very interesting. Now, Madam Adenola, maybe you can address yourself to. Okay, let this be taken by Jeremiah, Madam Jemima, because of the local context. Now, women, most of the elders in the councils are actually women. When the women are seriously underrepresented, Mr. Keloso has addressed himself to issues of capacity as opposed to gender. But my specific question is this: how can we ensure if the woman is not on the table, she's part of the menu, Madam Jemima?
Yes, that is the conversation that we are having across the country. If you're not on the table, then you should be part of the menu. We've been advancing the constitutional principles on equality and representation. That is Article 10 of the National Values and Principles of Governance, the rights of minorities and marginalized, and of course, affirmative action across board. Now, you see, we are not like Jesus, not Jesus, like the missionaries who just came and said, you must repent today, and if you don't repent today, you're going to die. We have to appreciate that it's a process to be able to change mindsets, to be able to change practices, to be able to appreciate that actually this other person needs to be on the table. In that regard, we give it training, retraining, building the capacity, and informing them about the constitutional principles. However, we're also advancing that if they're not among the 3 people who are sitting in the panel, then they should be there even just to follow, to learn. Because one of the things that they tell you, oh, you know, you're not learned. For instance, you go to notice and say, oh, the women are not learned. Yes, they're not learned, but they need to appreciate some of this is not about writing, but understanding the process. So can they be there seated, listening and following the procedures? That's number one. Then number 2, we also had these challenges where the women were not even given an opportunity to talk. When you want to talk, you're told that you have to talk through your brother or your cousin. And so we are saying that let's give them the opportunity to speak, because kitanda usichokilalia hujui kunguni wake. Like, you must be the one who feels the pain and the pinch. So we give them the opportunity to express themselves the way they want, the way the dispute has affected them. So in this regard, we've also enhanced their voices, even in this panel. So that is being part of the menu. And last but not least is going through the process in a systemic way, so that they can be able to have full representation. If you don't use that language they don't understand. Yes, we don't understand that language. Let's use translators so that it's not something that inhibits them from being part of the menu. So we've gone through stages of even developing guidelines, and those guidelines include issues of representation, issues of participation, issues of language, and enhancing just national values and the Bill of Rights in terms of being part of the process. Thank you.
Well said. Now I go all the way to Lagos to our panelist, Madam Adenola. Now, tell us whether what we are speaking about really resonates with Lagos. In particular, I always find women in Lagos very aggressive, very outgoing, and the go-getter, so to speak. The same when it comes to justice.
No, I would say yes. Nigerian women are very, sometimes they say their words, say their piece, speak their piece, as they would say. But however, when it comes to community, family, there's a lot of culture in Lagos and Nigeria. There's a lot of, you have to listen to your elders. As I grew up, that's the first thing I learned. You must listen to your elders. If they say left, it is left. If they say right, it is right. So a lot of women are also, they believe, especially in Lagos, marriage is the end goal. Getting married, having children, that is the end goal. So anything that moves them away from that path is wrong. Is seen as wrong to the community, is seen as wrong to the family. So if you end up in a situation where you are away from your family, or your husband is beating you, or they're not giving you what you need, the first thing is, how can we bring them back together? Or why don't you just come together. Well, even though the man may be wrong, he might be the one in the wrong, but it is more like the woman to maybe pray about it and it will be all right. Maybe just listen to me. He's wrong. Sometimes they frame it in a way that yes, the man is wrong, but you too just allow him to be a man. That is how it is. That men sometimes do things, they do these things. It's fine. It's just a part of the process, a part of marriage. So a lot of they frame it in a way that does not allow women to even go forward and accessing justice. Because at the end of the day, you might be ostracized from your family. Your family might be the ones even you pushing you back to your husband's house, pushing you back to the situation that you're running from. But now I think with the new young generation, a lot of them are speaking up against it. They are saying, no, I'm not even going to get married in the first place. No, I'm not going to listen to my elders anymore because what you are saying is wrong and I don't agree with it. So there's a lot of pushback, but I think we're moving forward. Even though it is teetering on the extreme, we are moving forward.
Well, I think we are moving forward and one conversation at a time. Now, Madam Jemima, there is a question for you on the chat. Like Juliet is asking, that the traditional dispute, okay, she was keen on the mechanism on criminal law. Can they be adapted and to what extent? That is first part of the question. I hope it's clear. Then she goes and says, women are often victims, but sometimes penalty clauses without restitution compensation does not assist women. She goes to say our traditional mechanism, on the other hand, may be patriarchal. I think you talked about this in serious crime like rape and murder. So apart from sentencing the offender, a traditional mechanism be enjoined to itemize damage to ensure victim gets material justice. Madam Jemima, maybe you can address yourself to this question.
Well, thank you so much. And that's even my topic for my PhD thesis. And it's all about restorative justice versus retributive justice. So our criminal justice system has been more focused on retributive justice, meaning punishing the offender, not looking at the victim's rights and the voices of the victims and what actually justice means to this victim. And that's why we are advancing for AJS, alternative justice mechanism, so that at least through restorative processes, community-centered justice, people can be able to not only express themselves, express that, yes, I committed this offense and I harmed this person, but also be able to reparate and pay back, compensate. In most cases, women are victims. They are victims, but when they go to court, first of all, you go to the police station, you are demeaned by the police officer and asking you, why are you coming to report your husband? Don't you know that you are married? When you go to court, you want to even testify. The first thing you are told, you want this man to go in jail. And so it leads to victimization for you even as a woman and even for you as a victim. Look at the issues of like stealing. Somebody has stolen from you. This person, yes, is going to be in jail, but have you gotten back what you really, really wanted in terms of reparation? So we are advocating for restorative justice that is holistic. So it not only punishes you as a perpetrator because you're able to stand and confirm that, yes, indeed, I committed this and I'm sorry. Apologize to this person, have a conversation to this person, but not to that extent only, to the further extent of repairing the harm, paying back that which you've stolen. If somebody has been assaulted and incurred expenses, even in terms of cost, then you're able also to pay back. So that's what we are advancing. Women are victims, yes. In criminal matters, it's very easy to deal with the AJS than even civil, because in criminal matters, if somebody has stolen, you're able to say pay back. In other cases, you are like, if it's civil, you need to have an order written down, documented. So you will need to go back to court for enforcement of that. But in these other cases, it's so easy to enforce. If somebody assaulted you and is able to take care of your hospital bills, like what happened in Babowino, I know most people did not understand the process. Babowino now taking care of this person who is in hospital, paying for the bill and everything. That is the kind of justice that victim really wants, rather than you being incarcerated. So it's very easy to enforce AJS outcomes in criminal matters than other matters. However, even in other matters, when you go, when you're in court, for instance, succession, You come and discuss and say, yes, we are agreeing that this is how we want to divide our properties. That one, remember, we still have to go back to court for us to get now the official grant to be issued. I hope I've been able to
Thank
answer
you very
that
much.
part. I think there were multiple of
Yes.
questions. I've seen a question asking whether AJS is the whole mechanic. Yes. AJS, Alternative Justice Systems, it's a system. We go back to what we learned about the solar eclipse, the eclipse. So in that eclipse, there are several, in the universe, we have the galaxy that has several stars. It has the planets. It has the, satellites and all that in that. So that's how AJS is. Inside AJS, we have different forms and different people that resolve disputes. We have the police, we have the chiefs, we have the civil society, we have the elders, we have mediation, we have arbitration, we have dialogues, we have the pastors. So we have all these people that we put together that we call now the alternative justice systems mechanisms. Thank you. Back to you, moderator.
Okay, while we are at it, and this goes to the women in alternative dispute resolutions, please asking whether we have AJS mechanism in this country. I think after this webinar, we can endeavor to share the same because I believe we have that. Now we'll cross all the way to Nigeria. Is it the same? Like what she has explained here in Kenya, retribution versus restorative justice, the punishment?
Okay.
Madam?
Yes. So most of the time, there's no restorative justice, especially coming from communities, issues. A lot of the time, the court decides something. So if the court essentially decides that this person is in the wrong, I feel like a restorative justice, aside from them giving you a monetary remedy or declaring a right, it comes with a lot of other things, even restorative justice in your community or in emotional restorative justice. So I don't think the court takes into consideration any of that. I think they're mostly very formal in just when you come to the court, you're claiming something. The court is not a Father Christmas, as they would say. They're not going to give you what you do not ask. So it is what is in your claims that you will get or not get. So they're not dishing out remedies, unfortunately.
Okay, very well. It reminds me when we were in college, so in criminal law, if you go to a court system and you're punished, the society does not care because you have been punished. But when you go through civil and you recover, then the society seems to benefit. Now, there is an interesting question here. Where is the boy child? Yes, there's something. Kudos to the Kamba community. I think for me, I'm also finding very good insights into the Kamba community. Incidentally, I'm taking this particular webinar from Machakos, so I'm very well taken care of. But Mr. Kilonzo, can you comment, where is the place of the boy child in AJS and traditional dispute resolution? Mr. Kilonzo, you're muted.
Sorry. For the boy child, I think we have overtly concentrated much on the girl child. And there's something I would like us to think about. In the creation, there are two stories of creation. There's one story where God created man and woman. That's the best story. But then there's a second creation where God created man and he waited for some time and then he created a woman. And that is the one we use to downgrade a woman as a second-rate creation. Let us go to the first creation where they were both created equally. That one will take care of the man, the boy child, and they will take care of the girl child without emphasizing on either. Now, there's something I wanted to talk about briefly about the retribution and restitution. In the Kamba community, let's take a case where somebody has a car which hits somebody, and the person who was hit was on the wrong. So the court says there's nothing to be paid. The insurance out. For the Kamba will come out, call wazees, they sit down and agree. There's a standard payment for a man. There's a standard payment for a woman, and that standard payment will have to be paid. Whether the court says this person should be compensated or not. That is something which I think for us, we were more on a restitution than, the idea of, punishment. Thank you.
Cross over to Nigeria. Thank you very much. The Christian community is really shining today, and rightly so. Let's cross over to Nigeria. Is it this narrative that the girl child has been empowered at the expense of the woman? How does it fit with our topic today, women rights lens? Madam Udedoro?
Yes, please, could you repeat your question?
I'm saying that the narrative of that we have given so much mileage to the girl child at the expense of the, boy child. Does it sit? Because you don't remember our topic today, we are looking at reimagining traditional dispute resolution through a woman rights lens. So are we shooting ourselves at the foot?
No, I don't think so. I do believe that we focus more on the girl child than the boy child. I think, yes, the boy child has issues in the sense that we have a lot of responsibilities that is placed on them immediately when they are in power or when they are given a sense of responsibility, as well as sometimes they're the ones that take the brunt of discipline or abuse that is packaged as discipline. However, I do think the whole empowering the girl child is for a specific reason, because there's a lot of evidence and research that shows that the girl child is not reaping the same benefits as the boy child, or is essentially not what's the word? Is not They're not seen as valuable as the boy child, which is why there's essentially steps to empower them. If they were on the same level playing field, then we could argue, oh, they should be equally seen or equally valued. But in reality, the girl child is not even valued at the same level as the boy child, which does not mean the boy child doesn't have issues. They do. But let us focus on the girl child and bring them to the same playing ground.
Thank you. Very well. Now, I'd like to thank you very much for that submission. I'd like to give an opportunity to those of us who are logged in. If you want to unmute and ask your question, this is your time. Just unmute and ask your question. Who wants to go first? Can you put up your hand? Is there anyone who wants to verbalize their question? Okay.
Yes. Good afternoon, participants.
Good afternoon.
I have already asked my question. It has been answered, but I just wanted to start by commenting the speakers and all the participants who have joined. I want to pick Mr. Kangangi, Mr. Jemima, and our colleagues, just to say that, yes, AJS is there to stay. It's a new way of solving disputes. But as lawyers, we always know that the person who tells the best story wins the case. So even as we try and train our women on how to address issues, can we empower them with the skill to narrate the story? I like the idea about the Kamba traditional way of owning land. I think I've learned something I never knew about that. I'm proud of that the woman is at the center of everything. We call them waitu in our language. They take care of everything. So women are very, very important. And therefore, I want to commend women in ADR for having hosted this webinar. My students have joined online. They have learned a lot. And I would encourage that in the future, we can now go down to what Jemima is talking about, restorative justice and retribution. We'll be able to break it down in the concept of AJS and in the concept of ADR. The other thing is try to unpack so that people can be able to understand what is ADR, what is AJS, what are the very benefits we have when it comes to mediation, conciliation, and AJS. Otherwise, thank you very much, and may God bless you. Asante.
Thank you very much, Justin. Does anyone else want to unmute and verbalize their question? Going once?
Yes, Madam Kyoko. I'm just asking, is ADR telling us to stay away from courts? Are we saying that courts are too expensive? Courts are delaying matters? I thought we should be having a supplement, that we're supplementing each other, not like we're saying one system is bad and the other system is okay. Thank you. Just about.
Okay, Madam Jemima. Madam Jemima, address yourself to that question. Are we being told to stay out of courts? Madam Jemima, take it away.
No. We are not saying that we are shifting away from court. We are saying that these systems must complement each other. We must, as we promote, as we've advancing court, also we look at what does justice mean to even that person who cannot be able to access court, and be able to provide platforms and mechanisms for that person, because we're all looking at Article 48 of the Constitution. How do we address the needs of those who can access in court and those who cannot be able to access because of certain parameters? And one of the parameters is the issue of the cost, the issue of distance, because we have to be realistic about this. You go to Mandera, which is one of our biggest county, it has only one court station. So if you're to travel to that court station, remember, you still have challenges of means of getting to that court station. You still have the challenges of the cost of getting to that court station. So how do we now ensure that this person who has to travel 2 days or 3 days to access that court, you get to the court and then you're told that the court is not sitting? That is the reality. So can we open our minds beyond the city, where we have 5 courts within radius, a small radius, to now those people who cannot even access it? So remember, access to justice is not just about providing the structures, but is it accessible? Is it convenient for this people? The time that it takes, and we should be able to be realistic about this. Let's advance those who can be able to access court, but also provide mechanisms for those who cannot be able to access court. But however, even if you come to court, can you also promote a hygiene way in which court can work with other structures? And that's what Article 159(2)(c) says. Can you provide a hygiene way whereby the court promotes its duty to promote justice by working with other avenues so that they can enhance access justice for even you who has come to court? I think that's what I'll be able to respond to that. Thank you so much, Susan.
Thank you very much. That is a very good intervention, because as Jessica said, we have students here. Our students, we are not saying that we run away from court. We are just saying we complement these two justice systems. Now, Madam from Nigeria, the dollar, is it the same in Nigeria, whereby most people now seems to be favoring AJS or alternative as opposed to going to court? Madam Adedola? Madam Adedola, is she still here with us? No, she has joined all the way from Lagos. So, okay, no problem. Yes?
I had a question.
Oh, yes,
Hello?
please.
Are you able to hear me?
Yes, we can hear you, Juliet.
Sorry, I've been having a problem with my connection. I had asked a question on the chat about whether we have any policies on AJS or formal guidelines, because I know there's a lot of reforms in that area. And from the conversation we've had today, there are mainly issues of likelihood of women being disenfranchised, and maybe discrimination. So maybe, I don't know if it's today, maybe in a different setup, we might have to discuss those guidelines on AJS, if they exist, and peg them against whether women are really disenfranchised or are at a loss, because we have our constitution which provides for rights, So when you go to an AJS meeting or an AJS setup for dispute resolution and you're not given audience, that's infringement of the right to fair trial, discrimination. So maybe we could be guided on those guidelines. And then secondly, from the conversation we're having today, which I appreciate, the place of the woman, which actually is the place of the girl child, it actually started through affirmative action movement. So today we're in 2026, and I get what Kilonzo is saying. Are we still disenfranchised as women? Because there's a lot of women movement towards empowering women, even at grassroots level, matters to do with FGM. There are organizations going all the way to Samburu, marginalized areas, just to reach the woman and the girl. So what is the place of affirmative action right now? Is it the woman or the boy child? Because again, as women, we are mothers, huh? We are mothers to boys. So how is this conversation now going to go to the male gender? Because now we'll have to look at it as the gender perspective. Because from where I'm standing, every sitting must have a woman, at least. Every sitting must have a woman. So maybe we could look at it at that perspective. And are we women really disenfranchised? And what Jemima said lastly, sorry, I'm taking a little bit of your time. Is there a situation whereby after we have come up with a decision through the AJS mechanism, AJS in this case means we have sat with the chief, the village elders have been approached, they have come, they have resolved the dispute. Do we go back to court with that agreement so that it is adopted? And remember, once it is adopted as an order of the court, even if it's before the criminal court, then there is better enforcement mechanism through the court order. So I don't know if Jemima has looked at it from that perspective, and is it working on ground, or these are just things that we are thinking about and we're not moving towards that direction? Thank you.
Okay, thank you very much. I had asked Madam Adedola a question, but Madam Jemima, there is a question which has come on the floor. To the extent, do we have an AJS policy? Where do you find them? Can you address yourself to that very quickly? And now, after this, we shall go down to closing remarks. Madam Jemima?
Okay, thank you very much. I think those are very important observations. Yes, we have an AJS policy. It was launched in August 2020 during our celebration of 10th Katiba Day by Chief Justice Maraga. If you all remember, there's a time in 2014 or 2015 when Willie Mutunga made, the retired Chief Justice made some remarks. I said, we want to have a mechanism where people, witchcraft. So people took it lightly of that statement, but that's when he formed a task force to be able to go and learn and relearn about alternative justice mechanism and how to operational Article 159(2)(c). So for 5 years, the committee was chaired by Justice, the task force was chaired by Justice Ngugi with so many actors on board. By then I was at the DPP, representing the DP in the task force. So we came up with an AJS policy, which was launched now by Chief Justice Maraga in 2020, August. And then he set up a committee to implement, which was now redone by the current Chief Justice when she's promoting STARJ. STARJ means social transformation through access to justice. And our Chief Justice is promoting multiple doors to justice. So it's in this regard that in the process of implementing the AJS policy, we've come up with guidelines for different AJS mechanisms. As I've said, look at AJS as a whole spectrum that has different elements. So we look at different actors. So we have guidelines, and I think we look at an opportunity to share more on AJS and the guidelines that we have. In these guidelines, we advance not only building capacity, but representation, and we emphasize on representation of women, representation of persons with disability, representation of minorities in different communities, looking at the rights of marginalized, looking at the rights of PWDs, and even how do we involve the youth so that they are not left behind. So we have different guidelines and how we select and even appoint. It's through these guidelines that we've seen women now sitting in the panels, not just being the menu, but also being part of the decision making organs. And we've seen women then chairing sessions. And I think this one, even our panelist, who is also our champion here in Ukambani, can be able to shed more light. We hold annual conferences. Through these annual conferences, we learn from different ethnic communities and different people and stakeholders on how they're implementing AJS. This year will be in June, will be in Embu University, and we are starting this month with public lectures, webinars, training, online sessions on AJS, and we'll be sharing more through these platforms. In terms of outcomes, yes, we are working with the courts so that the courts have that duty under Article 159(2)(c) to promote alternative dispute resolution mechanisms. So once matters have been handled, how do they come back to court? And then the court adopts the same. So we call it doctrines of interaction. How does the court interact now with other AJS mechanisms? So it's a whole 3-day training on it, but I believe that we have space now to conceptualize AJS, what it is, and how we've been advancing it. I think today we are looking more on women and gender justice. But to finalize, somebody mentioned about the boy child. Did you know that in Kadhi's court, the Kadhis, all Kadis are men, first of all. But do you know that when women go to the Kadis courts, the men even fear because the rights of women are more advanced than those ones of men, and they've been complaining that ukipelekwa kwa kadhi, just know that your case is finished. So sometimes you need to create a balance and not say that because so and so is sitting on the panel, it will be against me because it's an opposite gender. We need to look at it from a holistic point of view and constitutional principles. Back to you, Daktari. Thank you.
Oh, thank you very much. We have students here. I believe they can visit Hadhi just so that they can see how the law interacts with custom. And I think the most important thing you have also said is the issue of June this year. You shall be in Embu University just to bring us up to speed on this. Now, Madam Adedola, we wanted to find out whether this narrative of boy child, is it so advanced in Lagos, or it's just hearsay?
Yes.
Madam
No. Yes. No. So it's not as advanced, I would say. I don't think I've heard it as much as a girl child as I've I feel like I've heard boy child more here in this webinar than I've heard it in Lagos. So I think here we are more empowering the women because we believe that they are being suppressed, evidently so, by the male generation.
Well, now members, I would want us to go to our closing remarks, and I would want to start with Mr. Kilonzo. We want to put the boy child, ahead. Please give us your closing remarks. 2 minutes, Mr. Kilonzo. You're muted.
Thank you very much. What I would say about the boy child is that we might go overboard. And we have seen even some podcasts about girls complaining that they need the boy child also to be empowered. And I think this is what is bringing in some of these, bizarre happenings of, murders, chopping of parts by the boys. So, when you push the boy to the wall, then he might react. And I'm saying this with a lot of, respect for the woman. Now, let me tell you, the role of the woman from the customary society has not changed much. The girl child has got a mother to mentor. The boy child has, in most cases now, has nobody to mentor. And actually they are left on their own devices. And if we push them too much, they are likely to break, and they are breaking. If you look at the school dropout rates now, it is higher for boys than it is for girls. Why? Because they are lacking role models. One, the role of the boy during the communal society was to look after goats and the cows. Now we don't have the cows, we don't have the goats. So this boy has got nothing to do with his energy. The girl is still there helping the mother in the kitchen. So this boy ends up with the drugs. So we need to re-engineer how are we going to re-engage these boys through this AGS or whatever system we come up with. Otherwise, if we don't do that, we are likely to lose them because they have no engagement as far as the community is concerned. What does the boy do? You find them either loitering in town, kicking a ball where there are no fields. We have taken up all the fields and we have constructed high-rise buildings there. So the boy's energy is actually sometimes directed into the wrong things, aggression. And I think that one, we need to address it. Now, lastly, I think maybe what I would like to say is about enforcement of the ADR. I think it lacks the enforcement aspect. And I remember sometimes when we had a meeting with the Judicial Training Institute, they told us in some places like Isiolo, the court had a mechanism where they will refer some matters to the council of elders, and then the council of elders would agree, would handle the matter, then the court will stamp it and enforce it. And I think this is what we need to go the way almost all over the country, so that we can have, eminent people within the community who can handle these matters, and the court would, authenticate and enforce. Because we cannot go back to the oral situations. We have to go to the written word, and the written word will be authenticated by the court rubber stamp. Thank you.
Okay, very well,
Unless
Mr.
there's any
Kalendo.
question, I think I've done my wrap.
Madam, yes, you've done very well. I mean, we really, even as I have to read a bit more about the Canva, I think definitely there are very good things that you can borrow. And I'm happy that where women in ADR this time, together with the judiciary, shall be going to Embu University. Madam Adedola, your closing remarks?
Yes, thank you so much for the opportunity to be part of this panel session. I would just like to wrap up to say that I believe that those us here that have the ability to be educated and learn from other people, I think we have a responsibility as well to go out there and also inform these women that they can also be on the panels that make these decisions. It is not just to have conversations and write articles and call it a day. I think people need to be actively telling these women that you can have an opportunity and pave the way. I had written my dissertation on coercive and controlling behavior, which was in University of Leeds in UK. And then they have a new Domestic Violence Act of 20, it's not as new anymore, but in 2021, it was very fresh and new. And they brought up a rule on coercive and controlling behavior. So behaviors that are not physical in the ways that you talk to someone, the ways that you control them, in the ways that you do things that are not physical but verbal, or the way you ostracize them or your community ostracize them, it is also illegal. It's also a crime to do that. But if you think about it, before that act was created, no one would ever have thought, why would we criminalize a coercion, or why would we criminalize your husband controlling you? He didn't hit you, so why are we criminalizing that? But now in 2021, it is now a crime. So I believe in the same way, now that we are saying, oh, why are women not on these panels? What can we do? I think in a couple of years, these things will be brought. We just need awareness and educating of these women. Thank you. Thank you so much for having me.
Very well said, and thank you very much. Last but not least, I'd like to invite Jemima for your closing remarks. Over to you.
Yes. Nothing for us without us. That should be our closing remark. We need to have everyone on the table. Don't sit far away from the table. Just be on the table. Even if you're just listening, it's okay. We need to enhance participation of all players, not just for women, for men, for the PWDs, for the minorities in different ethnic communities, for the marginalized. Let's bring everybody on board. When decisions are made and you're part of it, at least somebody can remember your rights are also important. But when decisions are made and you're far away from it, even people forget that you exist. So let's embrace participation. Even in outcomes, let's also embrace human rights so that we do not advance violations of any group, not just women, but violation against men, violations against the youth, violation against children. Let's just embrace that people have rights. These rights are universal. They must be realized. All in all, nothing for us without us. Thank you.
Well said. Nothing for us without us. I have a friend of mine who tells me that if there is no seat for her on the table, she comes with her own. Even if it's a stool, then just move a bit so that we can have a conversation. Very well said. And also there's somebody on the chat that they have said that advancement of women's rights have nothing to do with diminishing of men's rights, which I think it is somebody who said that, which is very, very important. Now, I believe there are a few takeaways. I think I would want to stop here. There are many, many takeaways. But from where I sit, I think it would seem that women in ADR, we shall be sharing the AJS or download it. Then also there is the issue of the ongoing conversation that really at the end of the day, we can't say women are here and therefore men cannot be here. It's really about a system part. But the most takeaway from me is that really this is an ongoing conversation. There was a time there whereby you couldn't even speak about women's rights. But here we are in the 21st century and we are still talking about women's rights. So the fact that we are having this conversation, for me, I think it's very important. And really, I'm a mother of both boys and girls. So when we talk about rights of children. It's really about men and women. But I agree with you that from the cultural point of view, we have really suffered. But suffice it to say that even looking at the webinar, we actually had more women and also men joining us. So it is not about us women and versus men, but it's just about collaborating and collegial, atmosphere for all of us. So I'd like to take this opportunity to really, really appreciate my eminent panel this afternoon, right from Lagos, Madam Adedola. We're really, really happy with your insightful, discussion. We hope that you can share your slides as you have their students. If they are not copyrighted, we would be more than happy, the students, just to have an appreciation of your perspective. Mr. Kilonzo, I think you have also given us some very good insights, and in particular on the Kamba community, which also it's been a very, very great opportunity. Madam Jemima, from the judiciary, I think you are doing a very good job, and you've also given us some very good insights and points of discussion. Now, without further ado, I just want to appreciate us even by saying that in the Bible it says that you can make food, but you have no visitors. Our attendees, our participants, we really, really appreciate your time this afternoon. It is not that you didn't have anything to do, but you deferred gratification so that we can be with us. We really appreciate your time here. And thank you, everyone, for your time. I submit back to Women in ADR for closing session. Thank you very much. Over to you.
Thank you very much, Dr. Susan and team. You have done a wonderful job. Dr. Kilonzo, you have done a marvelous job. Jemima, you have schooled us all. And I think you have really demystified this thing of AJS. And probably share with us the paper we can put on our website. People can get to it. Because clearly you're talking about something that we are all asking. What are their policies? What are they saying? And the fact that we have guidelines. Please feel free to share with us that we can share with our members, and also just in the process also get to the public. This has been a marvelous talk also from Our Lady Adedola from Nigeria, whereby in Nigeria, you say cultures are a bit different here and there, yes? But when it comes to Nigeria, their last word is marriage, you know? And to Nigerians, that is very critical. It's important. And the beauty of AJS and ADR is that the solution suits the parties. So we will not impose what works in South Africa to the Egyptians and vice versa. It's a matter of when you go to the ground, what is it that works with these people? What is acceptable to them? So that it is acceptable to the community where they are and as at a whole. And I really like what Dr. Kilonzo has said. And my dad was not a Mukamba, but that is one thing he said very specifically. This particular land will go to the boys. And there is this land, it will go to the girls. Should any of them come back. But the interesting thing, landed as we are, our brothers don't want to give us that land. I mean, that's the reality. You find even us, we are landed, but we still have to fight for some of these things. So we find that we really have to school our people. We have to empower the boy child. We like it that the men are with us here today. And the fact that they are here, they learn that we are not out to outcompete them in any way, but we're here to collaborate. They may understand where we are coming from and where we are going to, so they can also be with us. It's very, very important. We are not against the boy child in any way, but whoever is saying that the women are now more empowered than the boys, let me tell you, the day I'll see Parliament 50-50, the day I'll walk to boards and find them 50-50, then we'll have met our threshold. But as it is right now, many boards you'll find one or two women, and you find the chairpersons, many times they are men. When we come to that place whereby the gender for men and women in the boards across the country are 50-50, yes. When we come to the parliamentary seats, all of them, they are 50-50. Then we'll have reached there. But as it is, we have not reached there yet. And I also like what Dr. Kilonzo said. The girl child has the mom holding their hand and the aunties. But there is a gap where the boy child is. But now what do we do as women? Because if my son comes to me, I'm blessed with my daughters. But if a son comes to me, I'll just tell him, Baba, Baba. So our men and the men who are here, please take up your role as men to really hold these boys, because there is a way we as women, there is a way we've been brought up, they've been nurtured. We nurture gently, and sometimes men, that gentleness will spoil them more. So they need a fellow man to tell them, hey, man up, come on, let's go, come on, you know. So there was a gap when they're no longer taking care of the goats. Our men, again, they say they cannot compete with the cuckoos going back home, at least from my side. So they'll go to the pub. So the boy comes home, there's no daddy to tell him what to do. So the men who are here, please really take up your responsibility to hold these boys strong. I have a friend who, he said the first time he actually stayed with his children was during COVID. Because that was the first time he learned when the children go to school, when the children go to bed, what they eat and all that. Because I mean, the way the system is, when the man leaves in the morning, he comes back at 10. The children are asleep. The mamas are there. The most we can do as is membelas are them. That's our nature. That's how we are. We'll try and be hard. And I think when we try to be hard, we go overboard, you know? So men who are here, please take up your role. Take up your role so that you mentor the boys. We are mentoring the girls, but there is a way of mentoring the boys that we really cannot reach as women. And that's why we appreciate, and we always say when it comes to women in ADR, we are out to empower the women in whichever way we can. We do not diminish the value of men, but we focus on women, because that is where there is a gap. Look at the governors, how many of them are women? Look at parliamentarians, look at what. So we have not yet empowered the women to the position that is required. When they'll reach 50-50, we can say we have, but that does not mean that we are negating the boy child in any way. Having said that, I'm sure we are all happy to be here today, and we encourage all of us who are here, but they are men, we call them friends of women in ADR, to please, if you have not registered to be a member of Women in ADR, please do so. We have shared the link in our chat, and you can also always reach out to us. And the amount that we pay, when you consider what you get from Women in ADR, is worth it. This value for your money. So the individual for individuals, is somebody talking? Individual membership is 5,000 per year. Then for students, it is 2,000 shillings. And for the corporates, it's 25,000 Kenya shillings. That is per year. And there are many benefits that come with it. We give you visibility. We enable you network. And when I talk of visibility, it's a session like today. Those who didn't know Jemima now know Jemima. Now you can talk about Adedola in Nigeria. Dr. Kilonzo, with his wealth of wisdom, now you can reach out to him and even refer people. Look at the wonderful work Dr. Susan has done. And this is something we usually offer our members. You can get a chance to present your paper. You can get a chance to moderate. And there are many benefits that come with it. It's not just about money. Many times, if you just go for money, you'll not reach your goal. Go for what you like, what you're passionate about, and the money will start streaming in. So we do encourage those of us here that are not members, please join us. Those who have not updated their membership, please do update your membership. And now that you have seen what we have shared here today, our brothers, please encourage your sisters to join Women in ADR. Yes, we are in Kenya, but our footprint, our dream is across Africa. We want to be that organization that you go to when we are talking about ADR. The presenters have also done very well, saying it's not just enough for us to put women on the table, but we want women who are competent, merit. And that is one thing we are really focusing on, to make sure that the women we are in our space, we enable and empower these women to competently sit on dispute boards, and handle any kind of dispute, depending on where they are placed. Amongst us, we have arbitrators, we have mediators, we have conciliators, we have trainers, and we have those in the building society, we have those in the medical, we have educationists, all of us together speaking one language and trying to see how we can empower each other for a better tomorrow and to be able to competently sit on a dispute resolution table. We don't want any of us fearing any assignment in the dispute resolution space. And in the event that you are given something that you feel you cannot handle, you can always ask us, is there somebody competent enough in the group to handle this? Let us not say we can't do it and that's the end of the story. If you can't do it, just hand it over to us. We can pick amongst us who can handle these matters. So that we start being called like Kofi Annan was being called. I mean, that would be my dream personally, to be called all over the world to go and settle disputes. So women, well, yes, we are doing domestic, it's business-wise and all these other areas, but really this is a space where we can grow. And as women in ADR, our desire is to position women for ADR. And we position you by ensuring that you're competent enough by you attending these sessions, attending the trainings that are available, and we have a lot of engagements. If you have a paper, you tell us. We can see how we can bring other people together and listen to you and critique it in a good and positive way, so that we are all above par on international standards. So basically, that please join our membership. If you have not, join. If you have, renew, and also just spread the gospel about women in ADR. Thank you very, very much, everyone. The panelists, you've done a splendid job. And for the participants staying with us till this moment, a big bravo to you all. Thank you, thank you, thank you, thank you. God bless you. Yes, we can live at our own pleasure.
Thank you, everybody.
Thank you.
Thank you so much.
Thank you, Adedola. Next time we're in Lagos, we'll look for you.
Yes, please come
Thank
over.
you.
Well done.
Yes. You've
Thank
done
you.
a beautiful
Bye-bye.
job. We really appreciate.
Bye-bye.
Bye-bye.
Bye-bye.